Hello and welcome to the Herrington Carmichael video blog for December 2015. My name is Alistair MacArthur and I'm the Head of Employment with Herrington Carmichael. I've got 5 developments to talk to you about in employment law and HR practice in the last month. So let's start with tribunal fees. As many of you know, tribunal fees are a very hotly debated subject in the world of employment law and HR practice. In the last month, the House of Commons Justice Committee has heard evidence on the impact of tribunal fees. In particular, there have been a number of interesting comments around these, and the general view is that tribunal fees are dissuading employees from issuing claims, which will come as no surprise to many of you who are employers. In particular, a couple of comments. Working Families estimated that 1.2 million employers will only receive a tribunal claim every 60 years. The Federation of Small Businesses also commented that the level of fees is quite now disproportionate to the level of wages, discouraging people from issuing claims. Moving on, gender pay gap reporting. This is coming next year and we're expecting regulations around March time and we'll bring you more detail then. However, the government has announced in the last month that the gender pay gap reporting will not just include pay but will also include bonuses, and we can expect a development on this to other forms of pay as well. Exit payments or termination payments for public sector workers have also been capped in the last month to £95,000, which will apply to payments for voluntary and compulsory redundancy, payment in lieu of notice and other added payments which may be paid on the end of employment. Holiday pay again has come up in the last month. The case of Greenfield versus the Care Bureau Limited gives a demonstration to employers to how to calculate holiday pay where there is a variation in the working hours of an employee. In this case, the employee asked to change their working hours, and at the point of the change, the court said that the calculation of holiday pay has to change. So everything up to the change is calculated on the old working hours, and from the change in working hours, the new calculation of holiday pay will apply. This means that there will be a variation at the point when an employee asked to change their working hours, and employers will have to have their heads screwed on to recalculate holiday pay at that point in time. Also, the case of Science Warehouse Limited and Mills gives us an indication of how the ACAS early conciliation process applies to new causes of action that arise during an employment tribunal claim. In this circumstance, the court held that there was no need to follow the ACAS early conciliation process again, and the case continued even though there was a new claim being pursued by the claimant. That's everything for this month. We hope you're enjoying these video blogs. This is obviously no substitute for proper employment law advice, and if we at Herrington Carmichael can be of any assistance to you, please don't hesitate to contact us. Lastly, on behalf of myself, the Employment Department and the whole of the firm, I wish you a very Merry Christmas and a Happy New Year. Thank you and goodbye.